5, 4, 3, 2, 1. The expression cognizance was explained by this court as it merely means become aware of, and when used with reference to a court or a judge, it connotes to take notice of judicially. It indicates the point when a court or a magistrate takes judicial notice of an offence with a view to initiating proceedings in the respect of such offence said to have been committed by someone. It is entirely a different thing from initiation of proceedings. Rather, it is the condition precedent to the initiation of proceedings by the magistrate or the judge. Cognizance is taken of cases and not of persons. Under section 190 of the code, it is the application of judicial mind to the averments in the complaint that constitutes cognizance. At this stage, the magistrate has to be satisfied whether there is sufficient ground for proceeding and not whether there is sufficient ground for conviction. Whether the evidence is adequate for supporting the conviction can be determined only at the trial and not at the stage of inquiry. If there is sufficient ground for proceeding, then the magistrate is empowered for issuance of process under section 204 of the code. Under the amended subsection 1 to section 202 CRPC, it is obligatory upon the magistrate that before summoning the accused residing beyond its jurisdiction, he shall inquire into the case himself or direct the investigation to be made by a police officer or by such other person as he thinks fit for finding out whether or not there is sufficient ground for proceeding against the accused. Relying on this judgment, learned counsel, appearing for the OP numbers 2, 3, and 4, submits that the learned court has rightly dismissed the complaint petition and not taken the cognizance. In reply, learned senior counsel, appearing for the petitioner, submits that the judgment relied by learned counsel, appearing for the OP numbers 2, 3, and 4, is helping the petitioner in light of para 26 of the said judgment. In view of the above facts and submissions of the parties, the court has gone through the materials available on record, including the 2 CRMP number 1510 of 2009 impugned orders, and finds that admittedly allegations are made in the complaint that on 6/5/2005 accused persons abducted the petitioner, and the learned court has found that on that day, in a proceeding before the civil court, the petitioner had appeared through a representation under section 317 CRPC and he was not present in the civil court. In that view of the matter, the learned court has come to the conclusion that the story is concocted. The line of argument advanced by learned counsel appearing for the petitioner is not in dispute. It is well settled that the inquiry under section 202 CRPC is meant for coming to the prima facie case. However, at the same time, it is the duty of the learned court to find out the truthfulness of the case. In the case in hand, on perusal of the order dated 6/5/2005, passed in GR number 2142 of 2002, the petitioner was represented under section 317 CRPC, and said section is meant for representation through the lawyer. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.